Hello and welcome back to my channel. I go by name of Dr. Heinz, and thank you so much for tuning in for another video. If you are new to the channel, thank you so much for choosing to watch this video. Welcome to my Crazy Thought Express. In this video, we are looking back on one of the cases that we have covered on this channel, and that case in particular is the Ari Jacob versus Taylor Lorenz and New York Times case. It is a very peculiar but interesting case because it dispels two narratives, so to speak. The first narrative it dispels is how defamation cases is now brought to silence victims, and that's what they're designed for, silencing victims, so to speak. And you may have seen my coverage of Amber Heard on this channel, loose coverage I should say, and that was a defamation case that was brought against her for writing on the Washington Post in regards to our op-ed. Now, this case is very similar because Taylor Lorenz, a journalist, wrote on the New York Times, and the article was called "Trying to Make It Big Online. Getting signed isn't everything." Ari Jacob, for you are liable for libel, as you are basically slandering me, and it has brought this case forward. Now, the other narrative that this dispels is journalists basically have this legal proof, and there is some basis to that because I don't think I've seen a lot of cases where journalists are directly sued, but I have seen a lot of cases where it's just the publication that's being sued. But this one is pretty big. If you've seen the previous videos that I've done where I detail the amended complaint, the judge's response to the complaint, and his decision to actually dismiss the complaint, the judge was Judge Ramos. He basically reserved 5 statements saying that if you can plead that there's enough inference for actual malice, we can move on. So from there, the second amended complaint came, and then we have a wave of motion to dismiss, then the reply, then the motion to dismiss, which we're going to discuss on the video today. So if you don't know the background of this case, those videos are a great starting point that I've done. It should be linked on the title card above. This video is going to take a different approach to the previous videos. What I am going to do in order to save time is to look at all these responses, like the motion to dismiss, the response to the motion to dismiss by Ari Jacob, and then the reply to that, and basically go in a story kind of flow to kind of show the back and forth bickering in document form. But to get acquainted with the case, I would implore you to at least watch the second amended complaint and the declarations videos that I've done in regards to the topic, because it does contain a lot of information that will be quite important here, especially the second amendment complaint, because that's where a lot of the evidence is for Taylor Lorenz shoddy reporting. So without further ado, let's begin with the first motion to dismiss by Taylor Lorenz. So the motion to dismiss, I'm only going to cover the preliminary statements in each of the motion to dismiss as I transition. I'm also going to cover one statement and why it should be dismissed, as well as the reply to the back and forth for this one specific statement, and then keep doing that for as we go on, so that we can get a train of thought going. But in each of these motions to dismiss, I will be covering the preliminary statement, and this one is as follows. It says, "This is the plaintiff's third attempt to plead a defamation action arising out of an article titled 'Trying to Make It Big Online. Getting signed isn't everything,' written by Lorenz and published in the New York Times. Declaration of Catherine Bow. The article offers a balance of disputes between Jacob and her former clients in the unique world of collab houses, where young internet influencers, many of them teenagers away from home for the first time, live together and post content on social media platforms like TikTok and Instagram in the hopes of gaining money and fame." The SAC, which is the second amended complaint, filed after this court dismissed most of the first amended complaint with prejudice, but allowed for a tailored amendment, is ripped from Twitter in both tone and content. I will stop here for a minute. I don't like that word he says dismiss with prejudice, because that's not that that's not entirely accurate. I don't know. I'm probably griping on nothing, but that just seems like I'm reading that. I'm like, wait a minute, with prejudice, how is she replying then? But anyway, it's probably a typo. It's probably nothing. Um, Far from abiding by the permanent by the uh, far from abiding by the permitted amendments, which only allow plaintiffs to plead actual malice as to 5 allegedly defamatory statements, the SAC and the accompanying press releases and publicity campaign is a blunderbuss attack on defendants. Not only did the plaintiffs dedicate most of the SAC to irrelevant and anonymous attacks on Lorenz, I bet you any money Lorenz typed this up, because she must have been butthurt being called a journalist. But they also added a new allegedly defamatory statements and 2 new causes of action. But this is not Twitter. Plaintiffs' social media positioning strategy does not work in this court because they have failed to do the one thing the court permitted them to do: plausibly allege actual malice to the 5 remaining statements. To the complaint therefore must be dismissed on this basis alone. The defamation claims should also be dismissed because plaintiffs failed to make a rigorous showing to plead defamation by implication. As for the new statement in suit, the pre-publication correspondence establishes that statement is substantially true. Finally, plaintiffs' new tag-along talk claims are well outside the scope of court's leave to amend and must be disregarded. Even if they were not, plaintiffs cannot state their claims for intentional infliction of emotional distress, IIED, and the torturous inference with prospective economic advantage, torturous interference, that is, because torturous interference, I meant to say, sorry. Anyway, it says because they cannot make out even the most basic of elements of those claims, plaintiffs' second amended complaint must be dismissed with prejudice. Also, all of these documents will be linked in the description. If you did not know that, how we do things on this channel, we definitely always link our sources wherever, in every video that we do, no matter how minute. The source that is being used will be linked, even if it's a live stream. So you can always go off and do your own research. That's what we encourage here. But anyway, on to the argument. So the argument is the court should dismiss plaintiff's second amended complaint prejudice pursuant to Rule 12b-6 of Federal's Rules of Civil Procedure. Despite its bombast, the amendment does not fix the first amended complaint's legal shortcoming, plausibly alleging actual malice for the 5 remaining statements. So it's a Rule 1206 is basically failure to state a claim based on facts. So because you don't have enough facts to carry the claim forward, it can be dismissed on this basis. So onto the arguments in regards to the statement specifically, which I'm covering today, is plaintiffs' amended allegations failed to plead actual malice to statements 3, 8, 9, 12, and 14. So first, as to statements 8 and 12, which I believe, if I'm not mistaken, is Tiana Singer not being managed by Ari Jacob, and statement 12 is regarding Mr. Young's nudes. Nudes being leaked by Ari Jacob. So she's making an argument around that. Plaintiffs add new allegations that Lorenz could have confirmed statement 8's falsity by reviewing the social media accounts of the influencers plaintiffs manage, or could have substantiated statement 12 by confirming with Devion Young's nude were leaked, or that influencers had no business partners. But actual malice is not measured by whether a reasonable, prudent man would have published or would have investigated before publishing. Instead, there must be sufficient evidence to permit the conclusion that the defendant in fact entertained serious doubts as to the truth of his statements, or had a high degree of awareness of their probable falsity. Accordingly, these allegations about what Lorenz could have or should have known are insufficient to us to establish malice. Rather, what matters is what Lorenz did know. The court rejected similar allegations in BYD's CO and Vice Media. The plaintiff attempted to plead actual malice by alleging that defendant had defendant investigated a source reputation on Wikipedia, Vice would have been put on notice that the source had been criticized in the past for alleged bias. The court rejected this argument, deeming that the mere fact of information existing online insufficient to allege actual malice, absent an allegation that Vice actually knew information actually existed. Just as by YD Co., plaintiff have pled the existence of information but no facts suggesting that Lorenz knew that information. Here, as those allegations are insufficient indeed, these allegations are more attenuated. Plaintiff's argument will leave defendants liable for every needle they would have to find in a haystack. The actual malice standard does not require that level of investigation. I actually agree with this one. I agree with this one because if you were to actually use that standard, that would force every reporter to just investigate every little thing that they do, and not just leave it up to them, their own discretion, because they do have a right to evaluate information that they receive. So, but I feel like this is a bit of a misrepresentation, because the evidence that was shown in the Second Amendment complaint in regards to this particular argument, in regards to Devion nudes being leaked, it was, from what I saw, it was more of Devion's nudes being sent by business executives, and Lorenz was approached with this information by Ari Jacob pre-publication, and I believe their argument was if you were to have this information, you should have gone on and investigate further, which I actually think it has quite a bit of merit. There's a case, I think it's Bangoke versus Yale University, where, just summarizing, he basically says failure to investigate after receiving evidence, like, had gone out to investigate, it would have helped your case in saying I'm not acting with actual malice because I don't have any serious doubt. And for a lot of context in the article, it wasn't actually her that said that Devion leaked it. It was actually Devion that alleged himself, and she just reported. However, on the Twitter handle, she basically said that she said it. So even that, and that was, after being confronted about the evidence. This was after the article was already published and out. To me, it's clear cut based on the case law that's around investigation. As she had just gone to Devion and just say, look, listen, I've got this information. Are you sure that Ari was the one that leaked this? No matter what Devion says, unless he says actually no, Ari wasn't the one that leaked it, and then she went ahead and published anyway, that's different. But if he says yes, it's not up to her like that. It'll be up to the fact finder to, because she can't trust her source, in my opinion. But anyway, back to the reading. So in the reply to that first argument, with a single page article, the article, defendants destroyed Jacob's livelihood. The so-called paper record sold its readers a bit of lies about plaintiffs and Lorenz's deceptive reporting tactics, willful ignorance of critical facts, and deliberate distortion all contributed to the false narratives about the plaintiffs that the Times have published. The second amended complaint cured one and only defect of plaintiff's defamation claim, actual malice. Defendants attempt to obfuscate, say that word properly, obfuscate, yes, Plaintiff's actual malice allegations by lumping them together and discussing them in isolation without their surrounding context. I think this is in regards to the statement 8 and 12 that I was talking about earlier. This turns the legal standard of actual malice allegations on its head. Ultimately, the court examination of actual malice would depend on this question: would the facts pled allow a reasonable juror to find that Lorenz's countless reporting errors, all of which resulted in a false and crippling negative portrayal of plaintiffs, were done intentionally or reckless disregard for the truth? The answer plainly is yes. In fact, it is the alternative explanation that Lorenz simply made mistake after innocent mistake that is implausible. Plaintiffs thus carried their burden of raising a reasonable expectation that discovery will reveal evidence of actual malice. I think I know who's writing that. That's gotta be Ron Coleman. Defendants also complain about plaintiffs' amendment to 6 defamatory statements and claims for tortious inferences with prospective economic advantage and intentional infliction of emotional distress. Yet these claims are both procedurally sound and substantively meritorious. Defendants' argument that the latter 2 claims are duplicative of plaintiffs' defamation claims fail for the simple reason that it ignores the factual basis of these claims, which are separate from the lies told in the article and the business losses that those lies caused. For the reasons herein, plaintiffs respectfully submit that the court should deny the motion in full and allow this case to finally proceed. Defendants published statement 3 with actual malice. Statement 3 asserts that Jacob told the kids next door residents that they would have to cover a larger share of a portion of the rent, but the contractual rent owed by the influencers never changed. And plaintiffs corrected defendants on this point 3 times prior to publication. Defendants tried to skirt liability by relying on the court's previous holding that denial is insufficient to show actual malice. The prior complaint merely stated that Jacob denied this contention prior to publication. However, the additional detail that the plaintiffs corrected defendants 3 times is material. What's more, the article simply states that unnamed influencers were told they would have to cover a larger share of the rent, without naming any influencer that allegedly conveyed this falsehood to Lorenz. In fact, there is no indication Lorenz received this information from an actual K&D resident. I see the argument. Okay. Given that plaintiffs have demonstrated, actually, I see the argument a lot. I'll get to that. Given that plaintiffs have demonstrated the false nature, so I see the argument, because what he's basically trying to say is that just because an influencer says it, your article has named all K&D residents. Why haven't you named this influencer that has basically opined this, has basically given this opinion in regards to them covering a larger share of the rent? That, is it an actual K&D resident, or is it someone that knows the K&D resident? That was never clear. So if they're making that claim, it would then go into the territory of, is this person reliable or not? But we'll see. We'll see how they respond. Given that plaintiffs have demonstrated the false nature of their statements regarding the rent, Jacob, the individual best position to speak as to the rent in the K&D house, thrice denied the false claim about the rent, and the article's contrary contention is based on an unnamed source. The court should infer defendants had serious doubts as to its truth, given that were obvious specified reasons to doubt the veracity of the information or accuracy in or of its reports. I see their point. That there should be an obvious and reasons to doubt the veracity of information. The defendants published Statement 8 with actual malice. Statement 8 asserts that Jacob promised Tiana Singer and the rest of the GIV influencers brand deals, money and opportunities that never materialized. While defendants carefully parsed their words to give their readers the false impression that Singer was yet another client affected by plaintiff alleged lies, Singer was not managed by the plaintiffs. By quoting Singer regarding the promised income that never happened, Lorenz gave readers the false impression that plaintiffs failed to deliver results for their clients. Further, defendants declined to publish the fact that plaintiffs signed agreements with GIV influencers did not contain any promises of band deals. I wouldn't agree that just because they failed to publish a fact, it means actual malice. I think there's a case law for that. Even it's like you don't. It could be as one-sided as ever, and it still doesn't mean it's actual malice. I think there's a case law for that. But it's just escaping my head. Even worse, Lorenz had knowledge of contrary facts. Plaintiffs' influencers frequently posted about brand deals and on other opportunities on their social media pages. Lorenz's social media trolling is so essential to our reportage that she keeps a detailed record of every single tweet and social media post she has. She's on every platform and uses over 30 Instagram accounts. That's an insane order to reach. If she said that for herself, that's an insane order. Based on these allegations, the court can reasonably infer, indeed, it is the only reasonable inference that Lorenz did fact see activity on these influencers' social media pages that demonstrated that plaintiffs had helped obtain brand deals. And even the opposite inference that Lorenz published the article without once consulting the influencers' social media pages would self-establish actual malice. In this scenario, Lorenz would have published injurious falsehoods about plaintiffs without doing basic research that quickly would have disproven our reporting, despite the fact Lorenz herself publicly boasts of how she meticulously reviews and keeps records of the subjects of our reporting. See Goldwater. Oh, that's an interesting case. I know about this case. Explaining that slipshod, sketchy investigative techniques about an item that was not hot news regarding serious charges can give rise to a finding of actual malice. Discovery would thus show Lorenz either intentionally hit her head in the sand on this occasion, or that she published the article despite the knowledge that influences social media pages directly contradicted her reporting. Both scenarios reflect actual malice. Moreover, plaintiffs sufficiently allege that Lorenz knew about the specific opportunities plaintiffs created for the influencers. Jacob told Lorenz over text message about a big opportunity, the playlist creator conference in Orlando, and an accompanying trip influences organized with sponsorship from a brand deal. Defendants try to downplay Jacob and Lorenz text message as just a hyperlink to a Google document with no reference to any purported sponsorship of the trip, or that any influencers, including Singer, would be in attendance. The Google Doc that Jacob sent at Lorenz, however, does establish that Singer was scheduled to travel to Orlando for the event. Lorenz does publish falsehoods contradicted by evidence that was directly sent to her. And several months prior to publishing the article, Lorenz herself reported that GIV, which is Girls in the Valley, held an opening party on March 12th at the Sugar Factory in Los Angeles featuring pop star Doja Cat, which independently confirms Lorenz's knowledge of opportunities plaintiffs provided to their clients. The importance of Playlist Creator Conference and GIV opening party as it pertains to Statement 8 is an issue of fact that the court must not resolve at pleading stage. I actually agree with this one. At first I was a bit lost because I was persuaded by the argument that was given by um Lorenz's side in regards to not being meticulous and investigating everything. But if if the hyperlink actually does actually show and prove that he was actually scheduled to be there and he was sponsored, and you went on and posted that he wasn't sponsored, I mean, the likelihood of you not clicking the hyperlink is so slim. Like, you were met with the information. It is reasonable to infer that there would have been some form of activity to actually go onto the hyperlink to check and confirm what is being said. It doesn't help your case that you wrote about these people receiving opportunities. But to be fair, that argument is equally strong. It does show at least that she is lying, but she did say it never materialized. So that does kind of give her a leeway, because the opportunities that others get is not the same as, yeah, okay, they had a chance to perform, to meet these people, they had a chance to do all this, but it doesn't mean that the brand deals never materialize. However, for this specific case, like I'm talking, I mean, that's away from the evidence of Doja Cat, etc. For this specific case, it wouldn't make sense for you to say that you never got a brand deal and you were sent a link to say he's actually sponsored to be there. That's that would entertain serious doubts according to the standard. That is very that should cause any reasonable person to be doubtful, even if you don't believe the plaintiff, even if you don't believe the link, even if you were in La La Land believing I am the optimum fact checker that knows every single thing, and I don't believe that because I actually believe he didn't sign, and I know it in my head because there's a contract somewhere that I haven't found yet, but I know it's there. Even if that was the case, you legally, there would be enough doubt. You don't need it's practically impossible to prove with direct evidence what you can actually think in your head. But this is enough. Now let's go on to the reply to the statements that was given by Taylor Lorenz. It says, defendant's opening brief demonstrated still further plead with acting with actual malice with publishing the article. In opposition, plaintiffs presented the court with a package reality, one where the court's narrow leave to amend was unlimited, where their out of scope tort claims are not redundant to their defamation claims, and where they have pled facts sufficient to adduce actual malice. But plaintiffs' efforts at a rebrand fail, and Rule 12b-6 mandates dismissal of this lawsuit with prejudice. Statement 3. Plaintiffs first claim defendants published Statement 3 with actual malice because plaintiffs deny the allegations therein thrice. Plaintiffs cite no case that holds that a reporter's knowledge of denial evinces actual malice. That's fair. In fact, many cases reach the opposite result. The defendant was free to evaluate information he received from various sources. Yeah, and his knowledge of plaintiff's denials did not establish actual malice. But I do agree with those cases that if you are presented with information, you have the right to evaluate said information and make your own judgment from there. Just because you deny it doesn't mean really anything. But the difference is, if you have been met with evidence, then you would have serious doubts as to the as to the truth of the claims. Actual malice cannot be predicated on mere denials, however vehement. Yeah, that's true. Plaintiffs also claim that 7.3 was published with actual malice because it relies on unnamed sources, but there is a difference between publishing an article based only on an unverified source and publishing an article based on sources known to the writers but not the readers. Fair enough. The Second Circuit has held that not naming a source in an article is not evidence that defendant believe the source to be unreliable. By Reverse Conde, again quoted here, plaintiffs have not pled that the unnamed source was known to Lorenz. Her reliance on it was not actual malice. Again, how is he supposed to play? How is he supposed to plead that without knowing what the source is? Like it hits me because how are they supposed to name this source that was connected to? I get the argument, but they don't have the name of the source anyway. So how could they pinpoint and say this is the source or that's the source? So statement 8. Plaintiffs argued that defendants acted with actual malice because Lorenz should have investigated statement 8. Plaintiffs promised influences, brand deals, and opportunities that never materialized by reviewing unspecified social media over an unspecified time. I think they stress unspecified. But actual malice is not measured by whether a reasonable, prudent man would have investigated before publishing. I'm glad they didn't make the gender argument because that would have been ridiculous. Like, but Lorenz is a woman. But anyway, it says it is measured by what Lorenz actually did. At 7 to 8, plaintiffs believe that Lorenz should have done more is not enough. Similarly, deficient is plaintiff's speculation that Lorenz must have known that plaintiffs procured brand deals for the influencers, but there's a caveat to that. There's this natural understanding to that because they sent you the link of the schedule. So that, anyway, because after the article's publication, Lorenz tweeted that she saves social media posts she sees. Plaintiffs make no attempt to connect the tweet to her awareness of posts that would demonstrate statement 8 falsity. I mean, she didn't really specify which tweet though. So this kind of falls flat as well. In their defense anyway, it falls flat because if you're saying that you save tweets, you didn't specify a specific time that you do this. If it's made within the lawsuit, the time of lawsuit, then that's sketchy because actually, yeah. If it's made in the time of the lawsuit, that's extremely bad. That's extremely bad. You're basically admitting, yeah, I saw an information that I should have looked further and I didn't. So from now on, I look at my tweets. It depends how I argue, but I personally don't think it's strong enough, if I'm being honest. Their failure to plead that Lorenz actually viewed any relevant social media makes allegations too speculative or to be plausible. In addition, this court held that the failure to review one's own files is inadequate to demonstrate malice by the party responsible for publishing a statement. Allegations about what Lorenz should have done do not show actual malice. If I could make an argument for the plaintiffs of having the unnamed influencer as well as Taylor's methods of going around and gathering information from the sources. Basically, this case is known as Goldwater versus Ginsburg in 1964. This case is very important because it led to reforms within the psychology industry that prohibited psychologists from diagnosing a client that they haven't met and evaluated themselves. So, or in other words, armchair diagnosis. They can't do that anymore. This case was the reason behind that. Because Ginsburg decided to write an article to say that he was unfit for office when he was running for it, that he was delusional, paranoid, etc. And the most libelous thing that he basically did was he basically done a questionnaire or poll. He had 12,000 or something psychiatrists take part. You know, he sent these questionnaires out to them. And about around 3,000 got back to him, or something around that number. The part that was very concerning was a lot of these responses had their names withheld, and it was just MD next to their names. That's what was found when this case went on. So that is very key here, because if you want to bring that into this case, you can look at the influencer that Taylor Lorenz actually put down on the article, and then you just have to question, well, you named all these influencers but you don't name this person. What are you trying to do, basically? So this basically sends the idea that, like Ginsburg, they were trying to send the impression that these doctors think that Goldwater is insane, is crazy, etc. And it was showing that the anonymity And the fact that it's using MD was really unreliable, and it inferred actual malice. The same way with Taylor Lorenz using the unnamed influencer, even though she only put influencer, she didn't really say what name it was. That's also inferring actual malice, because you could have just said an unnamed source told us, without trying to give the impression that it was actually an influencer. Is basically what I'm trying to say. In terms of the shady practices, is the same thing here. She has gone to these sources. She has spoken to these sources, etc. And we've seen from the declaration of Adam Cohen that she did not like when he declined to not take part in the interview. Again, that would be an inference to actual malice. Second, plaintiffs try to plead actual malice on statements 9, 12, and 14 by alleging that their communications with third parties not only established that the influencers had consented to the security camera in the GIV house, statement 9, that Jacob did not leak new photos, statement 12, and the plaintiffs that plaintiffs did not misrepresent their relationship with Ellie Zila, statement 14. But as this court noted, to allege actual malice, plaintiffs must bring home the allegations to Lorenz. Actual malice measures the speaker's subjective doubts about the truth of the publication. Consequently, actual malice cannot be pled without specific facts bearing on the speaker's knowledge. Statements by plaintiff to third party did not demonstrate actual malice, where plaintiff did not show that the Times was or should have been aware of that statement, purposely avoided it. Here, plaintiffs did not and cannot plead with Lorenz that Lorenz saw or even knew about those communications. Accordingly, allegations that an iPad in the GIV house required entrance to consent to video surveillance, that such practice is common industry-wide, that a Times photographer purportedly asked to sign in by an iPad, and that evidence of videotaping was visually apparent, cannot show that Lorenz published statement 9 with actual malice, because these allegations are not homed to Lorenz and included no specific facts bearing on the case, bearing on her knowledge. Similarly, plaintiffs cannot establish actual malice for statements 12 and 14 by pointing at text messages between two and other people about Young's nudes, or text messages between Jacob and Zila's mother, and an email between Jacob and other third parties, Zila's involvement with influences. Because plaintiffs do not and cannot allege Lorenz knew about these materials prior to publication. In this way, this case resembles Lindbergh versus Dow Jones. There, a plaintiff proffered an array of allegations regarding insurance that he claimed demonstrated falsity of statements published in a Wall Street Journal article. Critically, plaintiff failed to allege that the journal's reporters knew of any of this information. The court found that even if plaintiff's facts could show falsity, they could not establish actual malice, since they did not reveal that the reporters entertained serious doubts about their reporting. Here, two plaintiffs direct their allegations exclusively towards knowledge possessed by third parties, not Lorenz. These allegations therefore cannot prove that she published statements 9, 12, and 14 with actual malice. This is insane. So yes, there is a fact of falsity, because they had to concede that it is actually true that that she did sign the consent form, but Lorenz did not actually know about this from Ari Jacob. So they have got a point there. In the Lindbergh case, though, it wasn't dismissed outright. It was basically given leave to amend so that they can actually show actual malice. Lindbergh didn't actually amend the case. Like, he just didn't amend at all. It shows why they're suing the Times as well, because they're trying to, I guess, I'm speculating here, could be wrong, I'm wrong anyway. The Times, they're basically trying to say that the Times, knowing by their signature, because they haven't, they have given proof that the Times did visit, they wrote an article, that was actually established. And there was proof that there was a signature about these houses. That's actually established. To me, that's enough of an inference of actual malice, because they are defendants of this case. But their argument is like, Lorenz didn't know. However, if you're publishing it to the Times and you're saying that these people did not sign consent forms, I think the Bank OK case and the versus Yale case actually established this, that responsibility within an industry doesn't actually show or work in an actual malice test. And I'm making the argument because the Times does have editorial control. They do have the final say on what gets published. So if they had read this over and saw that basically they didn't consent, then they should have, it would have been something, especially when they know that there were consent forms at the place. They're like, wait, they didn't consent? It would have entertained serious doubts. That's where I'm coming from. But I don't know legally if you can bring someone else's actual malice and place it on, Lorenz, the person that you're actually going against. But they are defendants as well. So I would like to see the outcome for this argument, because in my opinion, I think this is Ari Jacob's strongest argument. But they're trying to argue based on technicality, and I don't know, depends on how it goes. It could get thrown out because it's not really saying that this is Lorenz's actual malice. But the fact that there's an article about it months prior, visiting this place, signing, is very unlikely that, I want to see I actually want to see what comes from that. Because that would be very interesting to see if the Times' actual malice is the same as Taylor Lorenz's actual malice, because they're defendants, or whether they're still separate. The question is, who covered that story? So if it was Taylor Lorenz that covered that same story, it's out of the water. Do you know what I mean? It's out of the water. Like, it wouldn't be a contest. But if it was someone else, that's different. You know what I'm trying to say? Like, defendants published statement 9 with actual malice. The third defamation statement defendants published with actual malice was a statement in the article that Jacob installed a security camera in the GIV house without residents' consent. Plaintiffs allege that everyone who entered the GIV house signed a release and waiver, noting the existence of video surveillance when they signed in on an iPad, and that it was well known in the content creator industry, including by defendants, that this was common practice at collaboration hours. Defendants contend that these allegations fail to show specific facts bearing on Lorenz's knowledge. We just read it. Defendants are asking the court to flip the governing legal standard by making an inference in their favor on a motion to dismiss. Plaintiffs' allegations demonstrate that a reporter with deep knowledge of the content creator industry, so much so that she is publishing her book on the subject, reported an unremarkable and industry standard practice as if it were a scandal. And the court should infer from these facts that discovery will produce evidence of reckless conduct. Given all the glaring clues that the residents had confirmed to filming, including the obvious presence of iPads mounted on the collaboration house's walls, but then again, it could be for different purposes. But then again, we had the fact that it was that, so yeah. Even Lorenz's failure to investigate thoroughly and verify facts shows actual malice, given the peculiar, harming, harmful, or damaging nature of the allegation that Jacob filmed young influencers in their home without consent. That said, then I'm concerned that they're not honing in on the Times on this. Anyway, plaintiffs could further amend their complaint to explain that Jacob and Lorenz discussed the influencer's desire to be featured in a reality show, which required the influencers to sign video release. Whoa! I did not expect that. Wait, you're saying that they even discussed featuring a reality show and would need to sign video releases? But how does that factor into the camera? I guess no, they're the same. They're the same. Reality show requires cameras. You would need to sign releases for this. This is bad. That's bad. Moreover, defendants knew from their communications with plaintiffs that the cameras were all public spaces, which each individual was informed about, and not in any areas where one would have an expectation of privacy, i.e. bathroom. The court should reject defendants' argument that notice is not consent. The correct inference on a motion to dismiss is that the influencers consented to filming that was disclosed on an iPad and visually apparent, as well as being industry standard. This is the Times further. Okay, now we get to the Times. The Times further knew that Jacob disclosed the existence of video surveillance to entrance of our content houses as a reporter, so it's definitely not Lorenz. From the Times, visited Kennedy House in May 2020 and inquired about signing in on the iPad. Defendant's argument that these allegations are not home to Lorenz lacks merit because the Times published the article and is a defendant in this matter. Yep. A plaintiff may prove actual malice of a press defendant by relying on the acts of all defendants' employees performed within the scope of their employment. So there is case law. This is citing Cantrell. Oh, okay. I did not read that case law. I don't know how I missed that. I did not read that case law. The Times, in addition to Lorenz, is therefore liable for knowing and publishing the falsehood that Jacob filmed Kennedy residents without their consent. The reply to Statement 9, which, as we've seen, the reply was listen. They are both defendants in this case. Let's see how they reply to this. Statement 9, plaintiffs next argue that because Lorenz was an expert in the content creation industry, she must have known the content houses usually had security cameras and therefore published Statement 9, which claim that security cameras were installed without consent with actual malice. This argument is like the one rejected in Nicosia versus Deroy. There, plaintiff claimed that the defendant was an expert on the event and therefore must have knowingly stated the falsehoods. The court, however, held that that the allegations that an expert should have known does not satisfy the heightened pleading standard for actual malice. Citing both Court versus Consumer Union, here too, Lorenz's expertise is not evidence of actual malice. In any event, plaintiff's allegation that Lorenz knew there were likely security cameras in the GIV house would not constitute evidence that Lorenz knew the influencers had consented to their installation. Oh, that's an interesting term. Installation. No, that's a stupid argument. Well, but I'll offer. Plaintiffs also argued that defendants knew of video surveillance in the GIV house because a Times photographer unrelated to the article once asked to assign an iPad at a separate K&D house. This argument fails because as this court already held, plaintiffs must show that Lorenz acted with actual malice. The state of mind of the required for actual malice would have to be brought home to the person in the Times organization having responsibility for the publication of the advertisement. Allegations about other employees at other houses are irrelevant. Not a bad response. Not a bad response at all. In all fairness, I think the case that they have even quoted is actually quite strong because in that case, it was actually separated. It was actually defined what actual malice finding actually is. it was actually made clear that it's a subjective standard that requires the proof rather than the objective negligence test, which is what they should have, could have, would have done. In this case, or in the way that case was being presented, it was what a writer would have known based on their expertise. This one is not really it's not really the same thing, because her expertise may be a journalist, you know, she's a writer, all of those things. That's what I'm understanding in terms of expertise. But it is not her expertise to understand. It goes into expertise versus expectation. If I'm being, if I am making any sense. So when I say expectation, I mean the legal expectation, or at least the legal understanding that that if you are to record anybody, you need a form of consent, especially within the industry. That's not really an expertise. You know, you're not really an expert when that is concerned. If I'm not sure if I'm making sense. It doesn't sound like you need to be an expert. It just sounds like you just need to understand the legalities around it. That if you are within the same industry, within the same, you know, you would understand, hey, it would entertain serious doubts to hear that you were not being, that you were being recorded without your consent. You'd be like, wait a second, where? Because that's the first thing that will come to you, that will come to your mind, especially if you're in the industry. You'll be like, wait, where were you being responsible? Because you would think, oh, the bathroom. I think them even misrepresenting the entire argument is weird to me, because now that they're shifting to the cameras, they didn't have consent to install the cameras. I'm sorry, you're shifting and you're coping hard. You have to be coping hard. Because since when did you need someone's consent to install a camera in the house? You need consent to record, not really install. It's not your house. It's like, it's my house. Like, I can I like, you know, like, it's my property. I pay rent. I'll do all this. If I am doing that, I can do what I please. I can have this camera here. My friend can come in here and cannot tell me, oh, you need consent from me to install that camera. Like, you need consent to have the camera recording me, but I don't need his consent to have the camera there. Like, that's if we want to look at the bare bones of the argument, installation does not mean you put it on the wall or you do anything. Me even mounting this camera here is a form of installation. So if my friend was to walk in here, I would need his consent, so to speak, to be around or to even be recorded if the camera was to be mounted elsewhere or even anywhere else around the house. So it falls flat. So now we're going to be looking at the arguments for the remaining statements in regards to actual malice coming from Lorenz's side. So for statement 14, plaintiffs claim that Jacob's text messages with Lorenz revealed that Lorenz knew that Jacob was being transparent about plaintiff's relationship with Elizela. Not so. Far from transparently. Informing Lorenz that Zela's mother had declined to retain influences to manage her daughter, and asked that her daughter be removed from the marketing deck. Jacob's text presented Zela's withdrawal from the GIV house as a pause because of corona restrictions. Indeed, the texts affirm rather than undercut substantial statement 14 substantial truth, because they highlight the seemingly continuing relationship between Zela and influences by informing Lorenz that Zela's mom is an advisor for me on PR. Wait, what? And influences by wait. Let me say that again. Wait. Let me read that again. Because they are like the seemingly continuing relationship between Zela and influences by informing Lorenz that Zela's mom is an advisor for me on PR. At no point does Jacob forthrightly admit that she is no longer working with Zela, or that she removed Zela from the marketing deck in in deference to our mother's wishes. Okay, I'll just be quick. I'll just be quick here. That's the same argument that they have made in regards to the Times for photographer going to the house and taking pictures. What does that have to do with having a contract with Zila? Like that. Let's just see the response in regard from Ari Jacob in regards to statement 14, because that, I mean, okay, we'll see what they say. I'm not gonna comment much on that one. Defendants published statement 14 with actual malice. Statement 14 asserts that Jacob made false statements about representing Ellie Zila, and that Jacob added Zila's name and photograph to influence his marketing deck without Zila's mother's permission. Again, defendants rely on their canned defense that the plaintiffs failed to bring their allegations home to Lorenz. Yet plaintiffs allege not only text messages between Jacob and Zila's mother and an email between Jacob and other third parties, but that also, as plaintiffs informed defendants prior to publication, that they never presented either Elizila or her mother with a management contract, and never represented to anyone in the industry that plaintiffs had a contract with the Zilas. Clear-cut argument. PR advisor, okay, but is there a contract of her being a PR advisor? Unless you're trying to say, actually, unless Taylor Lorenz is going to counter argue and say, actually, let's go to discovery. I'll prove there's a contract. It's basically saying, like, at this point, yeah, that's a very good argument, in my opinion. Lorenz knew from a text message exchange with Jacob that plaintiffs were going to pause on Elizila. The importance of this text message is that it shows that Lorenz knew, contrary to the article's depiction of events, that Jacob was disclaiming any professional relationship between her and Elizila. The court should reject defendants' effort to relitigate the substantial truth element regarding whether Jacob was forthright with Lorenz about the reason Jacob removed Zila from Influencer's marketing deck. It is Lorenz's speech that is at issue here, and Lorenz reported that Jacob was falsely holding Zila out as her client, when it's clear from Jacob's communication with Lorenz that Jacob did no such thing. What an argument. That's a really good argument. Let's get back to the point of actual malice, basically, is the argument. or rather than you try to dispute the truth of the matter, which is the fact that no, McLaren never presented a contract, rather than you trying to say she did, it was your speech that said that she didn't. So if you're trying to prove that she did now, what does that say about you? Basically, is the argument. What does that say about you? That's actually a funny argument, funny counter, I should say, because yeah, like trying to prove the truth of what you didn't write because you said that. Trying to prove the truth of what you didn't write is insane. That's just funny to me. That is just funny to me. But anyway, let's go and see how Lorenz actually responded to this matter. Statement 14. Next, plaintiffs argued that they have played actual malice as to statement 14 because the text message sent Lorenz shows Jacob disclaiming any professional relationship with Elizila. Plaintiffs overplayed their hand. The text messages informed that they were pausing on Zila because of COVID-19, but they never disclaimed a relationship. What does your article say? Hold up. I'm mad. I'm a little bit mad here. Let me quickly go to the article. Hold on. This is hold up, let me see this. So this is the article. It says Sarah Zila, 46, met Miss Jacob in April when Miss Jacob attended to design Miss Zila. Ellie to a management contract. Miss Zila declined, but soon discovered that Miss Jacob had already added Ellie to the talent portion relationships. Miss Zila emailed Miss Jacob. This is your actual malice right there. So you know communications exist. Okay, fine enough. Miss Zila emailed Miss Jacob and asked her to remove Ellie's name and image from the deck and stop referring to her as Ellie's manager. Ellie had heard from another people that Ari, blah blah. Last week, Miss Zila discovered that Miss Jacob was still telling people that she had management with Ellie. For any parent knows. Okay. So, reading that article, how are you arguing this? How are you actually arguing this? Next, plaintiffs argue that they have pled actual malice as to statement 14. You're proving actual malice because the text message Jacob sent Lorenz shows Jacob disclaiming any professional relationship. But your article said that they didn't have it because she declined it. They didn't have any professional relationship. So if from what I'm reading, unless I'm lacking comprehension, because unless Ari Jacob is actually arguing and saying no, we did have a contract, but she's arguing no, we didn't have a contract. You saying basically that I'm still talking to people in the industry, that I'm still signed, that Zeta signed with me, and going around saying it's management, but the mother who she's speaking to has declined this, and they couldn't go on. So what Jacob is arguing here is what Jacob was arguing in the previous in the reply was basically no, there was no management contract that exists between Ellie's mom and I, and she was not on the deck at all. So you bringing out saying that you're pausing the relationship is kind of proving our point, because she declined to work with a daughter, but yet you got a message that says we're pausing the relationship because of COVID-19, but never disclaimed a relation. What are you arguing, so to speak? I'm actually confused. What are you actually arguing? Indeed, a post suggests the relationship would resume post-pandemic, but you're arguing there was none because she declined. In short, plaintiff plead no direct evidence of actual malice for any allegedly defamatory statements. Undeterred, they argue that there is sufficient circumstantial evidence of Lorenz purported ill will shortly reporting to establish actual malice. These arguments are unconvincing. First, allegations of ill will, for example, that a reporter engaged in a systemic campaign of defamation, or that she harassed sources to tell her the right information, are applied of common law malice, not actual malice. Lemberg is a quote. Even if combining allegations of ill will with other allegations could show actual malice in other contexts, so they concede to that point because they know it exists. Plaintiffs have not plausibly alleged it here. The court had already rejected the Lorenz so-called economic motive as a UTA client shows actual malice. It also had held that articles discussion of Brittany Tomlinson and Gary Vaynerchuk, far from showing ill will, were true, privilege, or simply non-defamatory. As for the doxing allegations, plaintiffs do not simply plausibly allege that Lorenz purposely published Jacob's home address, as she did not know Jacob lived there. One second. That's my bullshit. This is the proof. Hi, it's Taylor Lorenz with the NYT. Can someone please send me the address for the Kids Next Door house, Grave Crib, Girls in the Valley house? Not for publication. Not for publication. Not for publication. Hi, Taylor. No prob. Will do. Hi Taylor, if you're not going to publish the addresses, why would you like them? Because we need to fact check. Now, that wasn't the purpose of me doing this, because I actually don't know about tortuous inferences as of yet. I only wanted to focus for today on the statement, so I'm not gonna go into that. But please, this is, come on. Okay. As for their doxing allegations, plaintiffs did not plausibly allege that Lorenz purposely published Jacob's home address, as she did not know Jacob lived there. So why did you publish the address? You said fact checking. So first, allegations of ill will, for example, systemic campaign, etc., or that she harassed sources to tell her information, are allegations of common law malice, not higher actual malice. However, you have Lorenz. There's evidence that she actually told somebody else that the address that she's obtaining is for fact checking only, not publishing. But she published it anyway. Whether she knew whether it was the address or not, her home address, which has to be the most desperate argument at this point, is irrelevant. It's immaterial, because she said that she wasn't going to publish it. That's reckless disregard, or might speak more to ill will to override that common law argument. Again, I'll just leave it. I'll just leave it there. I'll just leave it there. The next statements, now, I don't know how the court is going to treat that, whether they are going to accept that or not. Likely not, because I don't think I think from the motion to dismiss, I don't think the judge allowed room to bring in further allegations. I don't think he did, but he also didn't say that they can't either. So maybe it might get. I think there's a high likelihood it won't get accepted. That said, I do think there's a strong case that statement 9 regarding the cameras will survive. I think statement 12 in regards to the nudes will survive. Question marks on statement 3. Big question marks. I think that might get rejected. I think statement 3, if you don't know, larger share of the rent, I think that might get rejected despite there being proof. But I think that might get rejected. I don't think their pleading for actual malice was actually quite strong. In terms of the whole article, in terms of the actual malice of gathering the facts to do this, I think they got a very strong case there. And also to also address the point, I think she said that they needed a direct evidence to basically, have their case. Like, even in the Byro versus Conde case that is quoted by them and by the opposition, rightly so, it actually says actual malice can be proven, of course, by direct evidence. More often, however, actual malice is inferred through circumstantial evidence. It says because direct evidence of actual malice is rare, it may be proved, though, inference and circumstantial evidence. In my opinion, they have provided that evidence. Anyway, statement 8, might survive. Question mark on that. Statement 14, I think that's going through. So I predict 3 statements will go through, 9, 12, and 14. I don't think she even argued that one well. Regarding the other claims, I will look into that and I may make another video. But I hope that you enjoyed the breakdown of the statement so far, the case law that supports each statement. Thank you so much for tuning in. I am really looking forward to see how this actually plays out, and I really wish Ari Jacob the best of luck in regards to this case, because It is a tall order to take on the New York Times, to take on Taylor Lorenz, a journalist. No matter how bad she is protected by the machine. And yeah, Godspeed, really, because you're gonna need it. You're gonna need it. We'll see in court, etc. But and I hope it goes ahead. I really do hope it goes ahead. Thank you so much for tuning in to once again for another video. And on the next episode, I'll be looking at other cases. I'll be providing updates for Courtney Clenny. The state the state of Florida versus Courtney Clenny. There are developments in that, but I'll be looking more into the CCTV and how they handled it. And whatever developments there will be, I'll update there. I'll also be looking at the case of Shamima Begum. It's a bit different from what I usually cover here, which is mainly, if not DV, it will be defamation or cases of that nature. But this one is more to do with human rights as well as immigration. On the 7th, we are covering the Andrew Tate case, as well as Mason Greenwood and abuse allegations, SA allegations, etc. I'll be confirming the guests for that live stream, so do not miss that at all. Subscribe to the channel if you like the content that I'm doing. If you like what I do. I may not be a lawyer, I may not be a doctor, but I do believe that we can all have reasonable conversations. Thank you so much for tuning in to this channel once again, and hopefully you have a great day wherever you are. Take care of yourself. Bless.